Good morning, everyone. Welcome to the last day of the 2022 Justice Center Summit. So without further ado, I'm going to turn things over to Cynthia Pross, who's going to be doing the first part of the investigation.
Hi, thank you, Davin, and good morning to everyone. Welcome. We're happy to speak with you today about the Surrogate Decision-Making Committee program. I am Cindy Pross, and I'm here with Stephanie Dio. I have 20 years experience in nursing with the state and not-for-profit organizations under the oversight of OPWDD. I'm one of the nurses who reviews the cases before the hearing. And Stephanie, would you please introduce yourself?
Absolutely. Thank you, Cindy. Hello, I am very excited to be here with all of you today. My name is Stephanie Dio, and I am the Volunteer and Contractor Manager of the SDMC program. I've been with the program for 5 years in June, and my role is to oversee SDMC's wonderful volunteers and the 6 regional contract offices who hold major medical hearings across New York State. I am a licensed social worker, and I've always had a passion for advocating for vulnerable populations to ensure they receive proper treatment. I hope you enjoyed today's sessions. I'll now hand it back over to Cindy to get us started. Thank you.
Thank you, Stephanie. Together, we hope to give you a beginning to end overview of our processes. To do this, we're combining our overview presentation targeting providers who make the requests with information we give prospective volunteers to fulfill their initial training requirement. As we go through the program, if you have questions, please put them in chat. We will stop at certain spots to address them as best we can in this limited time available. If there are too many, we'll collect them and answer them after the session. To get a sense of the audience, we have a few poll questions. And here's our first poll. There are 4 questions. Please remember to scroll down. We want to get a sense of who you are. We'll give you just a little more time here. And remember, you're going to scroll down because there are 4 questions. Answer as best you can, what best fits. Okay, and I think we're ready for the answers. On the first question, you can see here OPWDD has the highest representation. I would say that is the highest representation in our cases. I agree with that. Unknown or none of the above. I do know from questions we received before the training was set up that we do have parents, and it's nice for you to be here, and we hope to be able to provide you an overview of the service and to entice you perhaps to be a volunteer with our program. Your primary job role, we have many administrators and we have those in other. We usually get a lot of care managers, house managers, and nurses who submit cases. It's great to see also some psychologists here. There will be some spots where we address what you might, how you might interact with us. Okay, so have you ever submitted a case? This is great. It's so nice to reach people who haven't used our services before to make sure that we give you the basic information. And some returning folks, terrific. And would you be a volunteer? We have such a great response here. I'm so happy for this. Stephanie, you're happy too, right?
Yes, that is wonderful. We're always looking for new volunteers.
Super. Okay, so let's get started and with our agenda. For our agenda today, we'll start off with the case submission end of things with an overview of our history, directions for finding and completing the forms, and a discussion of the 3 main topics addressed at the hearing. Stephanie will continue with describing the hearing process, how deliberation and voting works for our panel members, and the panel member responsibilities as public officers. The surrogate decision-making program was established by Article 80 of the Mental Hygiene Law in 1986. We were established in 1986 as a pilot program, only a few counties. This program proved to be successful in providing informed consent for people needing this support and was therefore expanded in the 1990s. Statewide expansion was completed in 2001. We support all counties in New York State now. SDMC was previously a part of CQC, the New York State Commission on Quality Care. And in 2013, when the Justice Center was established, SDMC became a part of the Justice Center. SDMC provides informed consent for people receiving services who lack the capacity to make their own medical decisions and have no legally authorized decision maker. SDMC program is not meant to replace family members or even the court process for consent on behalf of people who appear to be incapable of making their own decisions, but only to act when these preferred surrogates are unavailable, unable, or unwilling to make the decision on behalf of the person. A court of law remains one alternative, SDMC is another. SDMC offers many advantages to the person. There are caring, knowledgeable volunteers who believe in the benefits of our program. The volunteers make the consent decisions. There is no fee. SDMC supports timely medical care. We can generally process a case and hold the hearing for informed consent within 10 to 14 days. But in some urgent cases, we have held the hearing the same day the request was received. We include the patient and their natural supports in the process. The person in need of treatment, as well as advocates, receive notice of the hearing. Our process requires that the person attends the SDMC hearing, and personalized decision-making consideration is given to any preferences or opinions regarding the treatment that the person may express. We ensure due process rights are recognized with appropriate notifications and protections for the person. A point to note is that SDMC hearing only decides the current consent decision. A new major medical treatment or end-of-life plan generally requires a new SDMC case submission and hearing. We do not take away the decision-making rights of the person, but only address the current decision at hand, thereby encouraging continued self-advocacy. Why was it important to establish this program? Prior to SDMC, obtaining consent through the court system was impacted by delays and a backlog of cases. People were not able to receive their medical treatments in a timely way. We also had situations where people with disabilities were being allowed to sign their own consent when in fact they did not have capacity, as a means to circumvent the informed consent process. Procedures were labeled as emergencies when they were not true medical emergencies to avoid the court process. SDMC makes major medical and end-of-life decisions that require informed consent. Let me take a few minutes to review what informed consent means in healthcare. Imagine you're having a knee replacement surgery. To obtain informed consent, a physician or healthcare provider must explain a few things. Before we even get to the things on this list, the doctor must describe the health problem or diagnosis and the reason for your proposed treatment. You have worsening arthritis in your knee, for example. You need surgery. The provider must explain if the treatment is necessary now or if it can wait. In this example, the doctor may say, the pain and the difficulty with stairs is likely to increase if you wait. Then the healthcare provider should explain what will happen during the treatment, any pain or discomfort, and the expected recovery time. You will need surgery under general anesthesia. We will replace the joint with, and so on. You will need about 6 weeks of sometimes quite painful physical therapy after. A physician must explain the risks and benefits of the treatment and how likely they are to occur. In this example, you have the risk of anesthesia, including respiratory failure and death, which are low. You have the risk of infection, which is also low, and so on. And a medical provider should explain any alternative options for treating the health problem. You can continue with pain management and anti-inflammatory medications, which have their own side effects, but you said they're not working well enough. The treatment decision must be made voluntarily with the knowledge that consent can be withdrawn at any time. It is informed consent. You should have enough information to make the decision about your treatment. Your healthcare provider should also make sure you understand the information. The same holds true for a person with special needs. Informed consent is still required. The healthcare provider must evaluate understanding by the person, asking the person to repeat the information back in their own words, for example. The person should be able to provide plain language description of the treatment, the risks, the benefits, and the alternatives. It is chiefly the physician's responsibility to ensure a person understands and has the capacity to give consent for a proposed procedure at the time it's discussed. In the case of a person receiving services, it is also the responsibility of care providers to step in if capacity to give informed consent is in question. I will speak more about determining capacity in a few minutes. So what happens if a person lacks capacity to make a decision? For the general public, we have the option of completing a healthcare proxy, designating a healthcare agent to make decisions for us when we are not able to make decisions for ourselves, like if you are unconscious or on a ventilator. If the person with special needs has the capacity to execute a healthcare proxy, they can designate an agent. And I would refer you to your agency's legal support, your psychologist, or OPWDD OMH to discuss the requirements for a first person receiving services in executing a healthcare proxy. For people with intellectual developmental disability, mental health, or addiction supports, there is also law and regulation to support others making decisions requiring informed consent when the person cannot. Family is one option, and for those who do not have family, SDMC may be an option. Let's discuss a few specifics about eligibility. A person becomes eligible for SDMC major medical decision making if they are or have ever been in a residential program or receive services from a program operated, licensed, or funded by OPWDD or OMH. This includes case management, family care, or day programs. A person can also qualify for SDMC if they have ever had an inpatient admission to a psychiatric facility. We also consider anyone who has previously or currently received services in a residential alcohol or drug treatment facility through OASIS. We also would need a reason to believe the person lacks the capacity to make the decision. We'll discuss end-of-life eligibility decisions later. So what are major medical treatments? Major medical treatments include treatments with significant risk. This includes certain diagnostic tests that would require informed consent, such as colonoscopies, endoscopies, EGDs, or MRIs. It can be medical, surgical, dental, or diagnostic interventions that use general anesthesia or monitored anesthesia care or IV sedation. We will take cases that have anesthesia or need anesthesia regardless of what the procedure is. For example, dental x-rays and cleaning under general anesthesia. That would be a case for us. Gynecological exams with IV sedation, we would take that case. Or other kinds of routine treatment or exams that require anesthesia to facilitate the patient's comfort. Informed consent is necessary for procedures with significant invasion of body integrity, requiring an incision or producing substantial pain, discomfort, or debilitation, and have a significant recovery period. Anything invasive. So this would be anything from a simple biopsy to open heart surgery. Major medical treatment is also any treatment for which informed consent is required. There's no master list on the health department's website or in any medical textbook that says this is informed consent and this is not. it's a moving target. So we try to support when the doctor says they need informed consent. But I would rephrase this, anything with informed consent, because a few things come to mind. Most treatments we can provide consent for. We don't provide consent if there's a regulatory mechanism to address the consent within the agency. For example, we do not provide informed consent for medication to modify behavior, for medical holds to get a person comfortable and safe at the doctor's office, or immunizations like COVID. These are handled internal to the agency, and we restrict our cases to the ones considered more major medical, as I described above. You have, if you have any question about anything, a particular procedure, please contact us. At the end of the slide deck, you will have the program's email and phone number. What do we exclude? SDMC does not hear cases for routine diagnostics or medical care, such as blood draws, x-rays, physicals, urinalysis. Those kinds of procedures are routine and the risks are minimal and so well known as to not need disclosure. The exception would be if there's something specific or unique about the person that presents a higher risk. If there is a case where typically it would be routine, but this person is at higher risk because of a diagnosis, we might be able to take the case. An example would be routine dental for a person with hemophilia. We do not consent for emergency treatment. We are excluded from considering emergency medical treatment. Essentially, public health law allows the physician to proceed in an emergency without delay. If in their medical judgment, a delay in order to secure informed consent would increase the risk to the person's life or health. Dental care performed under local anesthetic, we also do not provide these consents. If someone is cooperative with their routine dental examinations, cleanings, and fillings under Novocaine, they do not require SDMC. Simple extractions do not require our consent. A surgical extraction, however, with possible incision, suture, or removal of bone would be a major medical case. Additionally, there are certain cases that would have to be addressed through a court process and would not come to SDMC. Electroconvulsive therapy, sterilization, and termination of pregnancy are expressly prohibited from coming to SDMC for consideration. In 2009, SDMC was authorized through an amendment with to the guardianship statute to make decisions to withhold and withdraw life-sustaining treatment for people with intellectual and developmental disabilities. This includes the DNR, DNI. This is only for people with a diagnosis of intellectual or developmental disability. And the person does not have to have been a service recipient. So this can be a person who lived in the community or a nursing home who has the IDD diagnosis but has never used specialized services. These are the types of medical orders for life-sustaining treatment, most that SDMC hears for people with intellectual and developmental disabilities. So there's your DNR and your DNI, withdrawal of artificial nutrition and hydration, and the withdrawal of antibiotics, hospice, those sorts of things, and anything that the physician feels is life-sustaining. To review our process, start here at the bottom, number one. Our process starts at SDMC when we receive a declaration. This is the series of forms. Approximately 1,000 cases come in each year. The declaration is submitted in one packet with all the forms and supporting documentation, a physical, labs, the consults related to it, and any tests that support the procedure. The nurse processes or reviews the declaration, follows up on any missing information, and then goes over the case with you to prepare you for the hearing. If this is your first SDMC hearing, please let the nurse reviewer who contacts you know this so that we can go over specific information on how the hearing proceeds and what is expected from the declarant and the nurse. Once the case is ready, it's sent to the regional SDMC contract office. There are 6 regional contract offices around the state who work with local volunteer panel members. The regional contractor prepares and schedules the hearing and then sends all the related notices and paperwork to the interested parties. The meetings are currently held by video, but before COVID, these meetings were in person, and the hearing would be with a panel, the person, and providers at a nearby location. Our regional contractor would record and facilitate the hearing. If you are the declarant, you are the point person for the treatment team, and you are responsible for communicating the day, the time, and if necessary, the location of the hearing to everyone on the team that needs to be present at the hearing to testify. The hearings are next. Most hearings are scheduled within 14 to 17 days from the time the declaration is received in our office. An expedited case, when the physician indicates that the care is needed very soon, we can usually schedule within 5 days. If you need an answer sooner than 5 to 7 days and rescheduling would risk the person's life or health, perhaps it's an emergency, and we can talk with you about this. The person must be present at the hearing as well as anyone testifying. Testimony is expected. Decisions cannot be made based on just the paperwork submitted. The decision is issued. The panel chairperson will read the decision into the record at the end of the hearing, and a copy of the decision and the consent will be distributed to interested parties at the end of the hearing. The declarant. I mentioned this term on the last slide, and I want to step back for a moment. There are a few definitions SDMC uses that will be important to understand our process. The first is the declarant, or some people say declarant. As I said, this is your chief contact person. This person submits the declaration, the paperwork. This person usually is a service provider, but can be any role in the person's life. SDMC does not direct who at the agency can or should be the declarant. It is a business matter you need to work out between your different job titles and job roles. This person should be familiar with the person's abilities. They should know or find out the status of any family, guardians, or healthcare proxy. They should be familiar with the medical needs. Next, the legally authorized surrogate. Someone who is legally authorized, willing, and available to make a decision. That would be the legally authorized surrogate. This can be a spouse, a parent, an adult child, legal guardian, healthcare proxy. They may be a surrogate, and other family can be a surrogate if it's an OPWDD regulated setting. When processing the case, we would like you to disclose to us the presence of any of these people. It helps to submit to us any documentation on why they're not making the decision. Are they not willing? Is the address unknown? Is there no contact with the person? Next, a correspondent. It is different from a surrogate. A correspondents have an interest in the person and have been participating in the person's care planning, perhaps visiting. The relationship is personal. It is generally not staff. It's not a member of the person's team. It can be friends in the community, a community advocate, maybe former staff who kept in contact. Also, we designate family care providers as correspondents. Correspondents do not have the authority to give consent, but the panel does weigh their opinions and testimony with the other evidence. They are invited to the meetings. We have another poll now. This one is to check to see if I have been clear on a few key concepts. So can we put that one up? Great. This one looks like you might have to scroll down to get all of the answers for question 2. So take a moment and read through these. Can everybody see the poll? Is there something that they have to open up? I see in the chat someone is having trouble with the poll. It popped up directly for me, so I hope you get that worked out. Okay, great. We're going to get to where sibling and family members are, and yes, they supersede the SDMC. So I'll show you that in just a minute. I saw that quick in your chat. I'm sneaking a peek. Okay, so are we ready with this poll? How are we doing? Let's see what we got here. Okay, so yes, SDMC is part of the Justice Center, and we are cost-free for the person. They don't need to hire a lawyer. They will get a lawyer through Mental Hygiene Legal Services, and that is no charge. It is used by people from OPWDD, OMH, and OASIS. Beautiful. And Stephanie and I, we do not make consent decisions. It's all panel volunteers. It is all community members who act as volunteers for our panels. Moving on to the types of things that require informed consent. And you guys did great with this too. Cataract surgery, any surgery will require informed consent. The dental exam with general anesthesia requires informed consent, and a liver biopsy, ouch. Pain and risk, yes, that's going to require informed consent. The ones that don't, the exam and fillings, it doesn't require informed consent. Most professionals across New York State will not require this. It is a general theme. If you have a particular facility that wants informed consent for everything, for anything, to see the patient, all of those things, we can talk about those as a separate matter if you've had experience with that. And blood draws. We do not provide informed consent for blood draws. Okay, so moving on from the slide. In the next section, I will discuss the declaration, the forms. If you have a question when completing the forms, you can find examples and a line-by-line video on how to complete them on the SDMC page of the Justice Center's website. So here we are on the website. You can arrive at SDMC, part of the Justice Center website, with a few clicks from the main page. But honestly, what I do, I Google SDMC forms. If I'm on the phone with you and trying to point you to the forms, I just say Google SDMC forms. It's typically the first result, and that will take you right there to our page. We're part of the Justice Center. This is the image you'll see, a hand with a pen. Our current forms are fillable PDFs that you download and can type into, but the idea is the same. The first step is filling out the forms. You can still use pen, but you know, how easy is it to stick it on your computer and type into it? And let's look at what these forms entail. The major medical packet, we'll start with that first. So this is the surgery, the biopsy, the dental under general anesthesia. That's this type of case. There is a 200, the declaration, with biographical information and a case summary. Fill in everything: emails, phone numbers, addresses, any possible surrogates, correspondence. If there's none, write NA or no. Do not skip questions. We need all of the information. Sign it and date it after you've read everything else in the packet. You are, as the declarant, you are the person who is the chief contact. You collect all of this and then send it to us. Okay. The 210 is the certification on capacity. This is completed by a licensed psychologist or psychiatrist. Each new case needs a new capacity evaluation, generally, because a person may be able to consent to one procedure but not another. A skin cancer removal in the dermatology office is much less complicated than a mastectomy decision. A person may have a capacity for one, but not the other. Ideally, the evaluation includes a discussion of the specific procedure in question. If the person has a profound disability, we may be able to take a more general statement about the lack of capacity. It is possible to have a nurse practitioner or master's or bachelor's level psychologist meet with the person and document this evaluation and have the licensed psychologist or psychiatrist co-sign the evaluation. The 220A is the certification of medical needs. This must be completed by a physician or a podiatrist or dentist if it is a foot or mouth issue. It cannot be a nurse practitioner or physician's assistant. This form must have the risks, benefits, and alternatives, why you need the procedure, and what to expect. Remember that the physician needs to explain these things to a person, the informed consent piece. Or in this case, it's explaining it to the surrogate decision maker. This form asks the doctor to write out all of these things for the panel to consider. It must be completed thoroughly. The 220B is related or supplemental medical information. It can be completed by anyone who has access to this information. Typically, it's the RN or the house director who do a great job with this, the house manager. It should include a medication list, a MAR, diagnosis list, and other basic medical history. Attach the physical and consults related to this issue. If you have labs and an EKG and a chest x-ray, great, add them. If you don't go get them. It is presumed the consent is predicated on proper medical clearance prior to the surgery if it is necessary. So please send it all in together. The next series is for end-of-life decisions. And remember, we are only talking about being able to hear these cases for people with intellectual and developmental disabilities. If you work with OMH, there's another place to go to, and we can refer you to who can assist with that. If you call us and you need a referral. Okay, so this series of forms, the 300, the declaration, again, it mirrors the other form. It has the biographical information and a case summary. Fill everything in, don't skip questions, and sign and date it after you've read everything else. The 310 is a certification on capacity. And this mirrors the MOLS checklist process for people with intellectual disabilities. And so that's a whole process with end-of-life decisions. So our forms mirror that as a surrogate decision maker. So what we ask for the certification on capacity is 2 physicians or a physician and a licensed psychologist or psychiatrist. One of the 2 clinicians needs to have formal IDDD work experience or the approval of the commissioner of OPWDD. So what we're looking for is that specialized training, specialized understanding of people with intellectual disability to ensure that the person cannot make a decision on end of life for themselves. The 320AB, the certification on medical need. This must be completed by 2 physicians. It cannot be a nurse practitioner or a physician's assistant. Any withholding of life-sustaining treatment must be specified. That whole list I went over earlier, if there's anything from that the doctor wants, it has to be written in here specifically. And the 330, it mirrors the form in the 200 series. This is supplemental medical information. So the RN, the house managers, they usually do really well with this form, or the social worker at the hospital can compile the information from a hospital very easily. So however you can get a hold of this information, it is necessary. Our panels need this to review. Please, again, send it all in together. With 1,000 cases, we cannot keep track of different pieces that you send in if you send it all in 1 week and then send me more next week. It's very difficult to manage. Moving on, the 3 hearing considerations. SDMC wants you to be comfortable testifying at a hearing. You should know what to expect in the questioning from the panel. This section lets you know about the panel and the decisions they must make in each case. When SDMC program was being developed, the legislators wanted the panel members to be those with expertise and sensitivity and interest in the care of people with special needs. They decided the panel should consist of one member of each of the following categories: a New York State licensed medical professional, a nurse, a doctor, a PA, OT, social worker, etc. They have a license to practice some type of healthcare in New York State. An attorney admitted to the New York State Bar. They bring decision-making skills and experience with ethics and the law to the table. An advocate, a person who works with or has worked in the field. They may advocate every day in their professional lives, or they may be concerned community members who volunteer to support people with special needs. And the family member or person who has received services in the past. Their sensitivities and their experiences are certainly valuable in helping making a decision for someone. What are the decisions? The 3 decisions. The first decision the panel member of the panel members concerns capacity. Does this person have the capacity to make the decision? And then the panel gathers information to rule out the presence of an authorized surrogate. If there is no other surrogate authorized, willing, or available, the panel members will determine whether the procedure is in the best interest of the person. This is the order that the questions are addressed, always beginning with capacity. First and foremost, the volunteer panel must decide whether the person can make a decision for themselves. And if they can, the panel members need to respect their decision to make their own choices, and this person would not need SDMC to provide consent for this procedure. If the preferred decision maker is always the person. All people coming before the committee have already had a formal capacity evaluation completed by a psychologist or psychiatrist, if it's major medical, which is part of the declaration packet that I just went over. Volunteer panel members review these documents prior to the hearing and establish the findings on the record at the hearing. The lack of ability to consent applies only to the medical treatment decision before SDMC at this time. It does not generalize to other procedures, future treatments, or other legal proceedings. Next slide. Thank you. There are several factors to explore when determining capacity before taking away somebody's ability to make their own treatment decision. Volunteer panel members will need to consider communication, understanding, appreciation, and reasoning behind the decision. So some areas to address are whether the person can communicate a choice. With this, the panel should consider whether hearing or vision or language preference are limiting the person's ability to communicate and rule this out as a reason they can't convey their choice. For example, if the person you support has a hearing aid, that should be worn for the hearing. Also, we want to consider whether the presence of new people or other factors are interfering with their communication. Panels will address the person and then ask staff further questions. The panel should address if the person can understand the reason for the procedure and the risks, the benefits, and the alternatives when explained in a straightforward manner. Panels will ask a series of questions to gauge the person's understanding of their diagnosis and proposed treatment. Additionally, the panel will want to know if the person acknowledges their medical situation and the possible outcomes with and without the procedure. This is appreciation. This often requires abstract thinking and to weigh future possibilities. For example, I know I have skin cancer, and if I don't get it removed, it will grow all over my body or even kill me. I know surgery could be painful and it could leave a scar. This is an example of abstract thinking, that abstract thinking that's necessary to fully give informed consent. And lastly, the panel will consider whether a person is able to articulate the reasoning behind their decision. I don't want my skin cancer to grow anymore or make me sick. It's bothering me now and I want it off. This is clear. A logical reason with the correct facts. Here's another model of how to look at capacity. There are the three elements. First is knowledge. We cannot show capacity on anything unless we first have the information. The procedure must be explained. The person must be given the information necessary to make a competent decision. Preferably, this has been done by the declarant or the nurse, already using language and terms the person understands. There are different ways to gain knowledge. You can provide information. The SDMC declaration requires that the person have the procedure explained. If it has not prior to the hearing, at the hearing, the panel will ask the providers to provide an explanation. Another way to gain knowledge is through experience. The panel may ask a person if they had the procedure before, and if so, what was it like? The previous experience may affect their capacity to make the decision the next time. Comprehension, the panel will evaluate if the person can retain and make use of the information. Does this person have the concept of illness? Can they understand and analyze and apply the information in a reasonable and rational manner in relation to their medical needs? Can they compare options and likely outcomes with or without the treatment? Can the patient repeat back all of the information critical to making this decision and explain the reasoning behind their decision? This allows the panel to access the patient's retention, assess the patient's retention of needed information and the capacity to integrate the information and arrive at a logically consistent decision, whether it's the same as the providers or not. The panel must be clear the person is not simply parroting back what has been shared about the procedure. The third element of capacity is voluntariness. A competent decision cannot be the result of an interfering factor which results in the person being unable to exercise free will, such as coercion, duress, denial, panic, fear, anxiety, even delusional thinking. For example, it seems it's not, the choice isn't completely voluntary if the patient feels compelled to do what a provider staff says. Why do you want the surgery? Because Dave, the house manager, said I should. It also might not be voluntary if there's a delusional belief about the treatment. I don't want surgery, doctors want to steal my organs. For psychologists and behaviorists, these last two models can assist you in completing your evaluation in a thorough manner. And importantly for the panel, documenting this clearly on the 210. And evaluation is especially important for person you support who has good verbal skills and speaks up with opinions. If the person does not comprehend or appreciate the illness or treatment or has flawed reasoning, it is helpful for the panel to have this pointed out in the 210. Point out your concerns that led to your evaluation of the person as lacking capacity. Psychologists always include specific content regarding your evaluation of capacity. The legal standard to consider when determining capacity and surrogacy is referred to as clear and convincing. Clear and convincing evidence is evidence that is highly reliable and upon which reasonable persons may rely with confidence in the probability of its correctness. The evidence must be clear enough so that each volunteer panel member is convinced that the person lacks the capacity prior to voting no. For surrogacy, the same clear and convincing standard is held. The evidence leaves you with a firm belief or conviction that it's highly probable that the person does not have a legally authorized surrogate that is available and willing to make the decision. So we touched on this before. On the next slide. SDMC follows mental hygiene law, but they also follow the regulations for the agencies with which we work. So firstly, from OPWDD, here's regulation 633.11. State regulations recognize the people on this list in this order to make major medical treatment decisions for people served by OPWDD regulated sites who are not able to make their own decisions. And yes, there's an update to this I direct you over to OPWDD's website, where it covers COVID vaccine. That's the only difference. COVID vaccine would also come before, would go to the agency rather than coming to us, your informed consent committee. A couple of points about this list: it is hierarchical. An actively involved parent, for example, would have priority in making a decision over the actively involved sibling. And as you can see with SDMC at the bottom, everyone else has priority before us in making that decision for the person. That is the hierarchical. So if this actively involved parent said no to a procedure, the doctor and the agency cannot move down the list to get someone else to make the decision. Even if the agency strongly disagrees with the parent, we cannot resolve this for you. Your agency administration and legal supports would need to assist you. You'll notice the term actively involved. This is defined by OPWDD definitions in 633.99. This is actively involved is having a significant and ongoing involvement in the person's life so as to have sufficient knowledge of the person's needs. There is no time or visitation requirement. Involvement in meetings. There is no definition like that. This is the intent for ongoing information. For providers, I would say if there is family involved and you update them in any way, and they say they don't wish to make decisions, it helps if you make that clear in writing to us. So if you have something in writing from the family signing that we don't want to make any further medical decisions, then great, that is very helpful. Or send us some pages from the life plan that explains that the person is no longer actively involved or who is making decisions. We need something for our panels, because remember, they need clear and convincing evidence there isn't family before they are comfortable making a decision. For OMH and OASIS, New York Codes and Regulations 27.9 about surgery and certain other treatments in mental health facilities. For people under the jurisdiction of OMH, OASIS, a spouse, a parent, or an adult child of the person may make the decision on behalf of those who lack the capacity to make their own decisions and who do not object to the treatment. And I'll get to that. There is no hierarchy and no requirement for active involvement. And notably, siblings are not included on this list of legally authorized surrogate decision makers. For OMH providers, even if it's clear the patient should have the treatment and the capacity evaluation states they lack the capacity to make the decision, if they do not want the procedure, SDMC cannot be the venue to resolve this. We would direct you back to OMH legal personnel to assist. The best interest. Best interest is promoting the personal well-being by the assessment of risks, benefits, and alternatives of a proposed medical treatment by taking into account the relief of suffering, preservation or restoration of functioning, improved quality of life, and the person's quality of life with and without treatment, and also the personal beliefs and values of this person. The patient's opinion regarding the proposed medical treatment is to be given full consideration by the volunteer panel members and balanced against the best interest needs of the patient, as well as their ability to understand and appreciate the consequences of their preferences. A hallmark of SDMC inclusiveness is the respect for autonomy. Volunteer panel members should be aware if the patient has previously stated a preference or opinion about the treatment. A panel is not bound by the person's opinion or preferences for cases from OPWDD regulated settings. However, the panel needs to balance best interest with those stated preferences when making a determination. The legal standard for best interest is a fair preponderance of the evidence, which is evidence that when weighed for its quality rather than quantity, that tips the scale to give consent or withhold consent for the proposed procedure or treatment. We get this sometimes with the issue of residential placement. A person with a proposed feeding tube or tracheostomy or permanent reliance on mechanical ventilation, we may consider the impact on where they live. Things to consider would include, can they return home with familiar people caring for them? Or will it require placement in a more medically skilled environment? How will this person respond? Will the treatment correct what the person has as an illness? Is it temporary? Should we bear with it and agree? How would they perceive the treatment? And we do discuss these things. Okay, so at this point, we are going to take a break. This concludes my part of the training, and we'll come back with Stephanie in 10 minutes. If you think of questions, put them in the chat.
Welcome back from the break, everyone. Before we start, we have a couple questions that we're going to be asking of the presenters. And before we start, I just want to reiterate again that yes, this presentation will be available to everyone who's attending. We'll be sending it out in the next day or two. And in the next week or two, you'll be able to find it on the Justice Center website. So fear not. All right, so the first question is, if someone needs consent for two unrelated procedures, can both be included in the same SDMC request?
I'll take it. Okay, Stephanie? Okay.
Yes, thank you.
Absolutely. We think this is great. So you're definitely going to need, with the 200 to be explicit, there are two procedures, and anywhere you're trying to describe the procedures, describe them there, make it clear that there are two and how the person reacted or any opinions they had about either of them. The 210 would require that you have the psychologist. It can be on 210 certification of capacity, but you can have the psychologist or psychiatrist comment on both procedures. They can talk about both procedures, the colonoscopy and the dental under anesthesia, for example. We get this a lot. It does make it there are some complex nuances to it, but great, do it all at once, because then you have one hearing. You will need two separate 220As unless it's both are done by the same doctor, so certification on capacity. In my example for the colonoscopy, your GI will fill out one, and the dental under general anesthesia, the dentist will fill out the other. And again, you can just do one 200 and one 220B. They have one set of MARs and one set of medical history. So that form, we really would only need the one. Okay.
Thank you very much. Great answer. Can you talk about, we got a few questions about the OPWDD MIPS program, the medical immobilization. How does SDMC complement or contrast with that? Do you need to go through SDMC for this?
Okay. We do not provide consent for things that there are other regulatory mechanisms for. And back in 2010, there was an ADM for MIPS, medical immobilization and protective stabilization and sedation. So this is a papoose or medical restraints while you're at the dentist's office to make sure the person is comfortable and safe, or sedation, a pre-sedate, an Ativan so that they're comfortable. Those sorts of things are so very common. The mechanism was really best put in the hands of some sort of informed consent committee within the agency. And since we had this COVID recently, there were so many people needing the vaccine that it was decided between SDMC and OPWDD that really that vast number would put our case count triple quadruple, etc., multiply our case count so much it was unreasonable. The best thing to do was to put that also in regulation, allowing the agencies to take care of those kinds of cases. So things like COVID, consent for behavior medication, and consent for MIPS or medical holds, those things in OPWDD settings are back with the agency. We have provided consent for, I think, one COVID vaccine for a person who where the agency did not have such a committee. But we, again, are below everything else everyone else who could be a surrogate. So we come last. If you have an informed consent committee, it has to go there.
Thank you. Can SDMC be used by OCFS facilities or licensed programs?
No, the mental hygiene law does not allow this.
Okay. And do parents have to, if parents have a child who's over the age of 18, do they have to go to court to be declared a surrogate for the surrogate decision-making process?
No, if the person is supported within OPWDD regulated setting, or in OMH, if the person lacks the capacity to make a particular decision, that hierarchy I showed you for OMH, it's just a list, but in OPWDD, there is a hierarchy, and it's actively involved. So actively involved, not necessarily a guardian, does have the authority to make an informed consent decision for their family member before coming to us. So let's say your daughter is over 18, she lives in an IRA, and she needs an MRI. She doesn't understand it. You can provide the consent. The doctor should take your consent. OPWDD central office can help you if you're having any difficulty with that, or the agency's administration.
Great, thank you. That's the last question. All right, Stephanie, I'll turn it over to you.
Thank you. And thank you for all of those great questions and the answers, Cindy. So in this part of the presentation, we will focus on the hearing process and the roles and responsibilities of panel members. So let's get started. We're going to talk about how to prepare for an SDMC hearing. As Cindy mentioned, since COVID, SDMC hearings have been held remotely through video conference on WebEx. Prior to COVID, SDMC hearings were held in person, typically at an individual's residence or a conference room at a hospital for end-of-life hearings. SDMC sends a notice of hearing to the 4 panel members and interested parties that informs participants about the date, time, location, and reason for the hearing. A meeting invite is also sent from the regional contractor for virtual hearings. Participants receive a copy of the 200 series major medical or 300 series end-of-life case packet, depending on the request, to review before the hearing. The case packet includes the medical certification from the doctor to explain the person's medical prognosis and need for recommended treatment, a capacity evaluation completed by a licensed clinician that documents the person's lack of capacity to comprehend the risk and benefits associated with the procedure, and any supporting medical documentation that is needed, such as any consults, physicals, labs, x-rays, and notes to support the request. Panel members should always take notes and formulate questions based on the information received in the packet to prepare for each hearing. Volunteers should refrain from conducting outside research and contacting the physician before the hearing. It is really important that questions be addressed on the record at the hearing. Volunteers do have the option of contacting the SDMC nurse who processed the case if they have any questions or concerns with information in the packet prior to the hearing. When agreeing to serve on a panel, volunteers must ensure they have no conflicts with the agencies providing services to the individual due to employment, financial, connection, or family relations. We always have guidance on our website for volunteers, and there's the volunteer handbook that will help to strengthen volunteers' understandings of the SDMC hearing process and address some of those common trends that happen during hearings. So always refer to our website when you have questions too. Providers also need to be prepared for the hearing. They will need to answer questions on the 3 issues of capacity, surrogacy, and best interest, which Cindy has touched on. For capacity, the panel will want to know how the person makes their needs known, what types of decisions, if any, they make independently, what a typical day looks like for them, and if they have ever consented to major medical treatments in the past. And if so, what has changed making them unable to consent now? For surrogacy, the panel will address if the person has any family that is involved in their life that may be better suited to make the decision other than SDMC. It is important to remember that a legal surrogate must be authorized, willing, and available to make the decision on behalf of the person. The panel may also ask if the person has a legal guardian authorized to make the decision, or a healthcare proxy where the person has executed an agent to make decisions on their behalf if they weren't capable of making them. For best interest factors, providers should be prepared to offer the panel with a thorough explanation of the person's medical status, why the proposed treatment is being requested, the risk and benefits of the treatment, and if there are any alternatives that may be less invasive. For providers, we also have guidance on our website, so always make sure to take a look and look at some of that information. So let's talk more about the hearing. It is essential that SDMC hearings begin on time, as delays could impact other hearings that are scheduled after it. So please arrive 10 minutes early if you are scheduled to participate in a hearing. We count on our participants to support the process. The panel determination and medical care of the person could be delayed if there is also not enough panel members to hold the hearing, because SDMC is required to have 3 panel members present to hold a hearing. SDMC hearings are similar to a court proceeding with evidence and testimony gathered to support the medical request and person's lack of capacity to make their own decision. All participants providing testimony are sworn in and testimony is obtained for the record. SDMC allows hearsay in decision-making. For example, a provider may share what a particular doctor stated at a medical appointment to answer questions and support the proposed treatment. SDMC recognizes due process rights by providing a notice to all interested parties by giving them an opportunity to be present and heard at the hearing. SDMC considers the declarant, director, MHLS, patient, any surrogates, and correspondents to be interested parties. Registered nurses and care managers also play an important role in the care and treatment of the people we serve. So SDMC will also send them a notice of the hearing and the case information so that they can review it and be available and be present at the hearing. Mental Hygiene Legal Service is the attorney for the patient. They represent and advocate for the patient's best interest, but do not represent the SDMC program. That means that all legal and procedural questions should be addressed to SDMC, not MHLS. That's really important for our panel members to remember when they're participating in our hearings. SDMC is required to send notice to all interested parties at least 5 days before the hearing is scheduled, unless the case is expedited. In cases that are deemed expedited, notices still must be made, but only as soon as practical. The 5-day notice of hearing requirement is waived for expedited cases. Who participates in the hearing? So let's talk a little bit about that. The declarant, who is the person who completed the declaration, who is familiar with the individual and has an understanding of their medical needs. Agency staff, such as a registered nurse or care manager, the 4 panel members from SDMC, the individual, hospital staff, if the person is hospitalized, particularly for end-of-life hearings. A physician is usually present to support the end-of-life care plan. Any interested parties or correspondents and surrogates for the individual, Mental Hygiene Legal Service, and the local SDMC contractor for that region. SDMC does not have a requirement on what providers attend the hearing, but staff that can speak to the considerations of capacity, surrogacy, and who have medical background to support the request must be present. Next slide, please. SDMC creates a record of the hearing in a variety of ways. The hearing is recorded by video. Any information that is discussed other than deliberation is maintained as part of the record to support the necessity of the treatment and decision made by the volunteer panel members. Everyone must identify their name and role at the hearing, and this must be documented by the regional coordinator on an attendance sheet. The panel chairperson, who is one of the 4 volunteer panel members, reads an opening statement to begin the hearing. The chairperson will issue an oath to each provider testifying to affirm they swear to tell the truth while answering questions during the hearing. Testimony on the 3 questions occurs in the following order: capacity, surrogacy, and then best interest. Before adjourning for deliberation and voting, the panel chairperson will ask if there are any other information that the providers would like to share or further questions. Deliberation and voting is conducted off the record privately by the panel members. For the closing statement, the hearing is reopened. The audio recording of the hearing resumes. The panel chairperson will read the closing statement to share the decision at the hearing, and a written copy of the decision is issued with all interested parties after. The chairperson assists with the administration of the hearing with support from the SDMC contractor and staff when necessary. The chairperson's role is to open and close the hearing, maintain order and professionalism, close one issue before moving on to the next, and to redirect participants when necessary to keep the hearing on track. They should give everyone an opportunity to speak before the hearing is adjourned, and be willing to accept SDMC's support to keep the hearing on track and intervene when procedural questions arise. We'll talk a little bit more about the major medical hearings. SDMC hearings are scheduled by the regional contractor for the county the individual resides in and would be held in a convenient location for the individual and provider. As mentioned, right now, hearings are held virtually, but for most major medical hearings, when we are in person, the hearing often takes place in the individual's residential setting. Who must attend the hearing? Mental Hygiene Law Article 80 requires that the patient be present at the hearing if able. If the person has a medical condition or a behavioral condition that impacts their ability to attend, other arrangements will be made for a member of the panel to meet with the patient to assess capacity and their medical condition beforehand. With the current way of holding hearings remotely, patient attendance has been less problematic because when a patient is in the hospital, staff from the hospital can connect them to the hearing by video to participate, or staff and the residents can connect the patient to attend. Additionally, the declarant nurse and anyone else who is providing testimony concerning the individual, their daily life, whether there are any known family members or potential surrogates, and their medical history must be present. The mental hygiene legal service attorney is present as the legal representative of the individual and will usually meet with the patient for a few minutes prior to the hearing. The local SDMC contractor from the regional contractor office attends and is responsible for ensuring that all parts of the SDMC hearing are properly administered and recorded. The contractor will redirect panel members when needed and reach out to SDMC staff if procedural questions arise that they are unable to answer. With information obtained throughout the hearing, the 4 panel members will vote on the 3 considerations to make an informed decision that is in the best interest of the individual. Most decisions are made at the hearing. Next slide, please. Thank you. Major medical consent begins on the day of the hearing and is typically valid for 60 days, but can be extended up to 365 days if medically necessary for scheduling or treatment. The panel can also extend the consent period beyond 60 days if necessary at the time of the hearing or even after the hearing if the request is eligible for a conference call when there are unforeseen circumstances. Consent is not issued to a specific provider or physician for major medical or end-of-life decisions. When consent is granted, the consent is for that individual, not for a specific doctor. Additional consents are not required for admission, diagnostics, or anesthesia related to the procedure. They are all included in the SDMC consent. We also do not sign separate hospital or physician's consents. However, we often do sign hospice admission forms when hospice is included in the consent. The language on the consent allows the physician to make the anesthesia decision at the time of preoperative screening. So although we may discuss using IV sedation at the hearing, if on the day of the procedure, after a preoperative screening, the physician and anesthesiologist decide another form of anesthesia is most appropriate, that would be covered under the consent. Very often our hearings may grant consent days or weeks prior to the anticipated procedure. The physician can move forward with a different anesthesia plan without having to return to SDMC. The consent language includes the following. This consent is conditioned upon a current preoperative screening and in accordance with sound medical practice to determine the suitability of the patient to withstand the major medical procedure and the recommended form of anesthesia. So we always reference providers and doctors back to that language when they call us about anesthesia concerns. SDMC consent also allows a physician to move forward with a related procedure that is not more invasive, even though it may not have been included in the original application, and we may not have originally considered it during the hearing. If it is related to the treatment and it is normal and customary, the doctor can move forward with it. During a procedure, if the doctor sees a polyp during colonoscopy and the consent didn't know possible polypectomy, it can still be covered by that consent. Additionally, related treatment or diagnostics that are recommended after the procedure is performed can also be covered under the original consent during the consent period while it's covered. Always call SDMC if you have any questions on what a consent covers. We are arriving at our third poll question, so if that could be opened. Here we are going to see if people remember who is eligible for an SDMC end-of-life services. So we'll give participants about a minute to answer that question, and then we'll open up the results. Thank you. Okay, if we could show the results for this poll. Thank you. So most people got this correct. So SDMC is eligible, individuals are eligible for SDMC end-of-life services if they have an intellectual or developmental disability. For major medical decisions, we would cover people with a mental health disorder or a substance abuse or alcohol abuse disorder. But for end-of-life, it is specifically for an individual with an intellectual or developmental disability. It's great to see people are paying attention. Thank you. Next slide, please. So let's talk a little bit about the end-of-life hearing process. It's very similar to major medical hearings, with the exception that the individual is usually not present during the hearing when we're holding hearings in person because they're hospitalized. For a hearing to be held, the individual must be visited by one of the panelists serving on the panel to talk to the patient about questions regarding capacity. It is important that panel members talk directly to the patient and not hospital staff to ensure that their observation is solely based on their interaction with the patient and not influenced by outside conversations with the staff caring for the person. Once the individual has been visited, if we are holding the hearing in person, the hearing can be held and the panel member who visited the patient will report back to the panel during the consideration of capacity, their observation of the patient's condition, and any dialogue they had with them. So they're filling in the panel on the conversation that they had with the patient or any observation if the patient isn't verbally able to communicate. Then questions would be directed to the providers during the hearing to testify on why they believe the individual does not have capacity and if the individual ever voiced any wishes regarding their moral or religious beliefs at the end stages of their life. It is important to know if the individual mentioned any preferences about their end-of-life care so that the panel can take their wishes into account when making a decision. When hearings are held remotely, questions are addressed to the patient at the hearing because hospital staff are able to connect the patient by video. Residential staff have some of the most important information concerning the individual's baseline and what their life was like prior to their decline in health. They also have information concerning who is a part of the person's life, including any family members or visitors that may be involved, and if they have any opinion on the proposed treatment, considering their relation with the individual. In addition, the hospital will have information about the current medical treatment, prognosis, and burden of treatment. For end-of-life request, the attending physician and a concurring physician must certify to a reasonable degree of medical certainty that the person has one of the following: a terminal condition, which is an illness or injury from which there is no recovery and which can reasonably be expected to cause death within 1 year, or that they have permanent unconsciousness, or they have a medical condition other than an intellectual or developmental disability that requires life-sustaining treatment, is irreversible, and will continue indefinitely. A diagnosis of a potentially life-threatening illness isn't enough. There must also be an extraordinary burden associated with the life-sustaining treatment. The physician must note the extraordinary burden by considering the individual's medical condition outside of their disability, the impact of the life-sustaining treatment on the person's ability to function, the degree of pain the person may be experiencing either with or without treatment, the person's overall medical condition and transfer recovery, as well as the risks, side effects, and potential benefits of the proposed treatment. Weighing, is the life-sustaining treatment causing discomfort? Is it futile, providing no benefit? And intrusive or painful to continue. These are the extraordinary burdens. And it's perhaps the most difficult part of the process for us, for SDMC volunteers, in trying to make a decision on behalf of someone else. For our process in SDMC, it really is a decision that must be made with information from the medical providers and the residential staff. The physician may provide a description about the medical burden, but the providers have a sense of what this person enjoys and what burdens this person may or may not tolerate based on their individual characteristics. Let's say an individual needed to be transferred to a skilled nursing facility for indefinite mechanical ventilation. Considerations include, how will this be tolerated by the individual? Will the individual also need to be restrained to be prevented from withdrawing the feeding tube? And how does this individual react to new situations and surroundings? We would really want to consider their individual characteristics and what they would tolerate and what they wouldn't tolerate. Next slide, please. Thank you. In addition to other forms of life-sustaining treatment, the decision to withdraw or withhold artificially provided nutrition and or hydration requires a separate and distinct conversation by the panel. So if this is being requested, the panel needs to have a separate conversation on this. If someone needs IV fluids and tube feedings, then there's a proposal to take them away or not to start them. We need to make sure we have a separate determination as why it is appropriate to withhold or withdraw those, because food and water are considered basic human rights. To take food and water away or to withhold it, we need two physicians to agree that at least one of these criteria are met, that there is no reasonable hope of maintaining life, or that the artificially provided nutrition or hydration itself poses as an extraordinary burden. Some of the questions the panel may ask to providers and the physicians are, is the individual currently receiving artificial nutrition or hydration? Is this a request to withhold the placement of a feeding tube? Is further nutrition and hydration futile? And is this person actively dying? These questions can help the panel weigh the burden of artificially provided nutrition or hydration being continued. For example, there may be an individual who has an advanced stage of pancreatic cancer. The individual is not hungry, feels nauseous, and is on a feeding tube. The physician may be asking for permission to withhold the feeding tube. The panel may ask, how does the individual respond to feedings? Is further nutrition futile, and is it improving the individual's quality of life? The provider staff respond by indicating that the individual cries, vomits, and is experiencing a great deal of discomfort when being fed, that they have to monitor the individual carefully to ensure they do not aspirate. The physician provides testimony that the cancer is not likely to be cured, that it's progressing rather quickly, the individual is becoming weaker day by day, swelling has started, and the individual nutrition intake is not enough to support life. In this case, the continuing of artificially nutrition poses as an extraordinary burden because it is futile, it is painful to the individual, and it's failing to improve their quality of life and would merely just prolong the suffering for them. These are the types of discussions we want to have during the hearing to see what impact the feedings or any treatment that they're getting is having on the individual. Comfort care can be requested in the end-of-life care decision. Comfort care is medical care and treatment provided with the primary goal of relieving pain and other symptoms and reducing suffering. It is important to note that physicians cannot extend additional life-sustaining restrictions that are not specified on the SDMC decision under a category of comfort care. If they check comfort care and they wanted to withhold dialysis transfusions, and that was not covered in the SDMC consent or discussion, the doctor would need to come back to SDMC to request consent to withhold the dialysis treatment. Comfort care can be used for something like oxygen administration for signs of discomfort rather than for treating low oxygen by measurement. Staff can add oxygen for the person's comfort rather than needing constant oxygen readings and thresholds. This may allow the person care in a community setting rather than needing to remain in acute care hospital or being transferred to a nursing home. If SDMC is the decision maker, our decision is issued in writing. The panel chair signs the 380A, and then the SDMC representative will co-sign it as a witness when we're in person. While we hold hearings remotely, the chairperson has someone in their present co-sign as a witness. All interested parties will receive a copy of the decision after the hearing. The notifications of the decision may begin after the hearing because the capacity and medical certifications are completed on the SDMC declaration forms, and the decision remains in effect as long as the person continues to meet the 1750B criteria of the medical condition and lack of capacity. It is important to note that if SDMC does not consent to withhold or withdraw life-sustaining treatment, any party may submit to the committee a declaration for non-emergency medical treatment or immediately resubmit an end-of-life case when new information is available. Interested parties and MHLS have the right to object to an SDMC hearing, but the weight of the objection differs by the role of the interested party and type of hearing, so major medical or end of life. If a legally authorized surrogate or person receiving services objects to the hearing, it stops. For major medical hearings, any other objections would be noted for the record. For example, if MHLS objects to the length of consent for a procedure, it does not stop the hearing, but the panel should weigh this objection when making their decision in deliberation. For end-of-life hearings, if any interested party or MHLS objects, it automatically stops the hearing. Let's talk about some of the potential hearing issues. Potential hearing issues could include high-risk procedures, possible capacity, avoiding treatment planning and offering testimony as a panel member, when a panel voices opposition to the procedure, and when weak testimony is presented by providers to support the request and answer questions during the hearing. There are just some hearings that are more complicated than others. This may be the case for high-risk procedures that could possibly equal or exceed the benefit based on the individual's medical history and prognosis. When it comes to capacity, it could be particularly difficult for the panel to assess an individual's understanding of a procedure when they have an intellectual or developmental disability, their capacity is questionable, and they are rejecting treatment. For hearings like this, the panel should ask open-ended questions to the individuals and providers to gather information on the individual's ability to appreciate the nature and consequences of the treatment, including the risk and benefits, outcome of non-treatment, and alternatives of the procedure. Providers who know the individual can give the panel insight on the typical reaction of the individual and if they may reject services on a typical basis without fully understanding their medical condition and burden of non-treatment. Again, you can always find guidance on any of the hearing considerations on the SDMC website. So if you have questions on capacity and you want to know how to prepare better, look at our website for detailed guidance. For OMH cases, if the patient states they do not want a procedure or treatment, the hearing would automatically stop. It can also be difficult for panel members to refrain from sharing their own personal or professional backgrounds during hearing. And, this wouldn't be allowed during the hearing because panel members can't testify, but panel members can share their opinions and information and background during deliberation. So hold those things for deliberation. So we are coming up on our fourth poll question. If we could have that open, please. So here, before we move on to talk about deliberations and voting, we just want to see if people remember the 3 considerations that SDMC panels are going to decide on at a hearing. So we'll give everybody a minute to provide an answer, and then we will open up the poll to see the results. Thank you. Okay, so if we could see the results. All right, so a lot of people got this correct. The 3 issues that panels are deciding on at a hearing are for capacity. Does this individual have capacity to provide their own informed consent? Surrogacy, is there a legally authorized, willing, and surrogate to make the decision on their behalf? And best interest, is the medical request in their best interests? Thank you. So next slide. Panels act together like a judge to make the decision for the individual. This is referred to as substituted decision making. Next slide. Only the 4 volunteer panel members may participate in the deliberation of capacity, surrogacy, and best interest. If the panel feels that the patient might have capacity while discussing an issue, they should deliberate on capacity before moving forward, because if the panel votes that the patient has capacity, they do not need to discuss if there is a surrogate or if the procedure is in the individual's best interest, because the patient would be deemed capable of making their own decision. Same thing applies to surrogacy. If an authorized, willing, and available surrogate is identified, the panel should pause to deliberate, because if they feel there's a surrogate better suited to make the decision other than SDMC, they do not need to vote and discuss best interest, because the panel would not be making the medical decision. During deliberation, the volunteer panel members have the sole discretion as to how much weight to give any specific evidence presented. Deliberation is private, as I've mentioned, and conducted off the record, and the panel is advised to weigh any objections by MHLS during this time. Volunteer panel members are allowed to share their own opinions, impressions, and knowledge with regard to the 3 decisions during deliberation. If the panel needs additional information in order to make the decision, the hearing may be reopened for additional testimony from the providers. If reopening the hearing does not provide the necessary information to help the panel make an informed decision, the panel has the option of requesting additional information, which allows them to reconvene at a later date through a conference call, which we will talk more about soon. The volunteer panel members must address the 3 questions in this order. Does the individual have capacity? Does the individual have a willing and available surrogate? And is the procedure in the individual's best interest? Panel member absences and delays could impact the voting process. Our voting process requires 3 votes to take away capacity, to agree that there is not an available and willing surrogate, and 3 votes that the procedure is in the person's best interest. If there are only 3 volunteers rather than 4, the voting must be unanimous to grant consent. These are the possible hearing outcomes at a hearing. Consent is issued if the procedure is approved. The 280A would be issued for a major medical hearing if consent is granted, and the 380A would be issued if consent is granted for an end-of-life hearing. When consent is denied, the provider has the option to submit a new case for consideration after 60 days, or whenever there is new information or a changed circumstance for the panel to consider. When a 2-2 decision is made by the panel in best interest, that means the panel has not been able to reach a decision. No outcome form is issued for hearings where the panel does not reach a decision. The providers have the option to resubmit the case to the SDMC program for review by a different panel immediately or when new information is available. The other hearing outcomes would be that the person has capacity to make their own decision, that the person lacks capacity but has a surrogate. Typically, the outcome is issued at the time of the hearing, and most often the panel usually grants consents. SDMC is vetting, issues of capacity and surrogacy while the SDMC nurse is processing the case. So usually we're really good at seeing, is this maybe not a case for SDMC because this patient could provide their own decision, or it seems like there's a family member that could be making this decision because they're actively involved. Occasionally, the panel may request more information when they are unable to make a decision at the hearing. They may find that they have additional questions or a second opinion is needed on the procedure in order to make a decision. In this case, the hearing would be adjourned and the providers would be advised on the new information the panel is requesting. The hearing would then be opened with new information when the new information is available through a conference call at a later date. We always advise our panel members to weigh the need for more information versus the need of the medical procedure, because it could delay the process if additional opinions need to be gathered, or if the other information needs to be gathered before we hold the conference call. So always weigh, is this really necessary information that I need to make a decision, or can I work with what I have now because this is really urgent and the patient has a procedure date coming up in 2 weeks. Conference calls are sometimes necessary, like I mentioned, when additional information is requested. However, any hearing may potentially be reopened as a conference call when there is a request to approve an extension of time on the consent, or when a physician wants informed consent for a related procedure within 11 months from the original hearing. If providers ever had a question on if a conference call could be held for a hearing that was already held and consent issued, you can always contact the SDMC program and we will direct you to the SDMC nurse who processed the case to look more at that. As a panel member, if you participated in a hearing where the panel requested more information, you should be prepared to receive a call once the new information is gathered to make sure that the panel can reconvene and make a decision at a conference call. You can also be contacted for a conference call where the panel granted consent if there is an extension or a related procedure within 11 months from the original hearing. When conference calls are scheduled, additional case information is sent to secure email, mail, or fax, and the meeting information and updated case information would be sent a couple of days or a week before the conference call, depending on how much time we have between them. SDMC volunteer panel members are considered public officers and have certain responsibilities that are important during the SDMC hearing process, and we're going to talk more about those responsibilities now. The role of the panel is similar to that of a judge in that the panel acts together to make a decision on behalf of the individual at the hearing. As volunteer panel members, it is essential to maintain impartial decision-making to uphold standards that promote fairness by not favoring one side over another or coming to the hearing with the bias about the proposed treatment before the testimony is presented. Volunteer panel members should approach each case individually without any perceived ideas or biases. Volunteer panel members may not provide information from their own knowledge or experience during the hearing. That would be considered testimony like we discussed. However, this is acceptable during deliberation. It's important that volunteers ensure they have no conflict of interest with agencies serving the patient. To assist with this, SDMC asks all panel members to disclose any agency affiliation or employment that may impact their ability to serve on a panel when joining as a volunteer panel member and when we do reappointment every 2 years to make sure that we have updated information. Volunteer panel members should also inform SDMC of any family conflicts with another volunteer in the program. We do have a couple of volunteers that are family in the program, or identify a conflict with an individual due to family relation or working with them in the past in an advocate or provider capacity. There is an expectation that volunteer panel members will conduct themselves in a manner that demonstrates integrity, fairness, and independence in decision-making. The decision-making needs to be based strictly on the best interest of the individual. Next slide, please. SDMC panel members are considered covered entities under the Health Insurance Portability and Accountability Act, HIPAA, a covered entity can use or disclose protected health information. Mental Hygiene Law Article 80, Section 80.07 allows SDMC to receive any information relevant to surrogate decision-making or for the proposed medical treatment. SDMC has access to it under the judicial and administrative proceeding. The major goal of HIPAA is to protect individuals' sensitive health information from unlawful and potentially harmful disclosure, while allowing entities access to individuals' health documents to support the continuation of care. Panel members should maintain patients' records as confidential. This includes information pertaining to the individual's medical condition, treatment plan, and protected personal health information. SDMC protects the information by use of secure email and the information when it's sent electronically or by mailing it directly to panel members when necessary. For in-person hearings, panel members should return their case packet to the regional SDMC coordinator at the end of the hearing so that all confidential documents can be shredded and disposed of to protect the confidentiality of the individuals we are serving. When we're holding hearings virtually, we ask that panel members make sure that they are securely disposing of confidential records. So if you downloaded anything on your computer, please make sure to delete it from your email, just to make sure that no one else could access this information other than yourself. If volunteer panel members have a conflict of interest with the agency submitting the declaration, or if they have a business relationship which could result in a conflict, they must recuse themselves from the hearing. As public officers, volunteers may not accept other employment which will impair their independence of judgment, disclose confidential information, use their position with the program to secure unwarranted privileges or exemptions, or engage in ex parte communication. Ex parte communication involves two or more parties regarding a proceeding without involving other interested parties. As we've discussed, discussions related to the case need to be happening at the hearing with everybody involved, and it shouldn't be happening outside of the hearing. This is concluding our SDMC overview training. I hope that you found it informative. If you would like to become a volunteer, which we hope you do, you will receive instructions after the training to visit the volunteer page to review the guidance documents and volunteer handbook that is on our webpage. You will also need to complete the post-training packet that gives SDMC a better understanding of your background and experience to serve in one of the panel member positions, along with your contact information and availability. For questions about the SDMC process or form, visit our website, which is being provided in the chat. And providers, please make sure that if you are scheduled to participate in an SDMC hearing, that you're reviewing the case information. A lot of times the volunteers will actually reference specific pages in the case, and that you're looking at our guidance to be prepared. You will be asked questions, and the more prepared you are, the better the hearing is going to go.
Thank you, Stephanie. There's just a couple questions that came up that you haven't yet answered. You answered many of them during your presentation, so good job. First question is, are hearings held during the course of normal business hours?
Yes, our hearings are usually held from 8 to 4 daily, from Monday through Friday.
Thank you. And what happens if there's an emergency medical decision needed during a weekend, or an end-of-life decision is needed during a weekend?
Cindy, would you like to answer that? Emergency treatment is outside of SDMC, but I'm sure Cindy can provide a little bit more information on that.
If something's coming up and you think it's going to be an emergency situation, call us and we can work together to describe to the doctors involved how they can go about using the two physician consent, or if you're an OPWDD, the 633 11 again, for providing consent through the CEO of the agency, that sort of thing. So we can give you some options, we can give you some directions, we can give you suggestions. But no, we will have no emergency procedure because Stephanie and I are not making the decisions. It is this whole process with the paperwork, the panel, and then the hearing that gets you your decision. Now, for end of life, there is no emergency process, and there isn't really an emergency process for two physicians or a CEO to make the decision. Those have to be handled court or us, or, you know, if there's a guardian or any other surrogate, great, that can go more efficiently, but we are the alternative. There isn't an emergency to physician thing for end of life. So we work our best, and we have worked getting a case on Friday and having the hearing at 4:30 on Friday, just to make sure the person goes into the weekend with the appropriate care plan. We do our best to provide this support. We cannot guarantee it.
Thank you. Do the requirements of a MOLST and MOLST checklist apply to an SDMC made end-of-life decision?
100%. Yes, our paperwork mirrors that. So when you actually have the MOLST checklist in front of you, the checklist is separate. The MOLST is the physician's order. The doctor writes it. The MOLST checklist for people with IDD was created to support the Healthcare Decisions Act, which gives special requirements for people with intellectual disabilities for doctors to put in place. So anyone uses this Healthcare Decision Act, except for the patient making their decision for themselves with intellectual disability, or if they had a properly executed healthcare proxy, it can stay away. But parent, sister, brother making the decision for a person with IDD on MOLST end of life have to follow the checklist. And the checklist process, our paperwork follows that. So you're mostly done when you use our process, but there are a few more steps, and we help you through that.
Okay, thank you. And the last question, the person missed it, but I think, you know, if they missed it, probably somebody else might have as well.
Mhm.
What happens when there is a deadlock on a panel's decision?
So when there is a 2-2 vote and they cannot agree on a decision, there would be no decision, which means that the providers would have the option of resubmitting a case if they felt like it was extremely necessary. And then the decision could be held before a new panel.
Thank you very much. Thank you, everyone, for attending. This was a great session, and I hope everyone has a great afternoon.
Thank you, everybody. Have a great day.